Recording has started.
Thank you. All right, good evening, everybody. Welcome to December 9th, 2025, Planning and Zoning Commission. Can we please stand and start with the Pledge of Allegiance? I pledge allegiance to the flag of the United States
of America,
To the republic
which stands one nation,
under
under God,
civil
indivisible,
liberty and
with
justice for all.
Great. Thank you very much. We will start with roll call, and I'll seat Eric Brodvig for, well, we don't have a full-time commission member yet, so just
You can still see this, right?
seat Eric Brodvig to make 7.
Yeah.
full-time. Yeah, that's what. We'll start down at that end.
Eric Swenson, Public Works Director. Go ahead. I
I
was just gonna say ex officio member.
Kenny Parsons, Commissioner.
Eric Brodvig, alternate.
Jeff DeRosa, Commissioner.
Mike Kozlowski, Vice Chairman.
Squirrel Graydon, Commissioner.
Online,
Todd Legnight, Commissioner.
Molly Dories, Commissioner.
Dave McCollum, Land Use Coordinator.
and here with us, staff.
Jeremy DeCarli, Interim Town Planner.
Amanda Martinez, Recording Secretary.
Okay, thank you very much. We will move on to item 3 on the agenda, which is the election of the officers for the upcoming year. Would anyone like to make a motion of a nomination?
Make the motions for Mike to be
Sorry.
Second.
To be what? To be what?
chair. To be chair.
All right.
I didn't get there.
All right, Kenny, Bob, second it. Take a roll call vote of commissioners. Mr. Legnard,
I vote for Michael Kozlowski for chairman.
Molly,
Michael Kozlowski, sounds great.
Kenny,
Second.
Yes.
Eric. Yes. Jeff.
Yes.
Yes, I'll be a yes. Jeff. I mean, sorry, school.
Yes.
Okay. So moved there. So I guess I am officially the chairman. Huh? Yeah. I'm gonna make a motion to make Jeff DeRosa the vice chairman. Second by Sproul. We'll start again up there, Mr. Legnard.
I vote for Jeff for vice chairman.
Molly?
Yes.
Kenny?
Yes.
Eric? Yes. Jeff?
Yes.
Myself, yes. Sproul?
Yes.
All right, Jeff is our new vice chairman. And lastly, I will make a motion to make Sproul Braden the secretary
As an interim.
for the short foreseeable future.
I'll second that interim secretary position.
All right, Mr. Legnard,
I vote for Sproul for secretary.
Molly,
Yes.
Yes.
Eric. Yes. Jeff.
Yes.
Yes, myself, Sproul.
Yeah, I'll move things around.
I was gonna say no. It's still in the back.
For the record. For the record. All right, so all that is taken care of. We'll move on to item number 4 of the public hearing continued for PCZ 2515-67 Greenwood Property LLC and 69 Greenwood Property LLC site plan, excavation and fill permit. The applicant has elected to move extend the meeting to January 13th. We won't get into any testimony, but I'll just say that a couple of people had emailed Jeremy DeCarli, the interim planner here, with some suggestions, and the applicant is taking those into consideration. One of those is a application that will be coming forth to us for a reduction in parking of the site plan itself. So that should be on the next meeting.
Yep.
Of the 13th. So we will continue those at that meeting.
If I can interject
Please.
just briefly, what I'd like to do is make a motion to set a hearing for that application, even though the application's not in. We'd like to get it on the books so that we can get a notification out there for the 13th, so that the plan can be
Okay.
Considered holistically.
So it is a application for a special permit for a reduction in parking.
Correct.
Okay, I will make a motion to set an application for 67 Greenwood Property LLC and 69 Greenwood Property LLC, a special permit for a reduction in parking to set the date for January 13th.
Second.
All right, all in favor?
Aye.
Aye. Any opposed? Any abstentions? Moved. Good. All right, we move on to item 4B, PCC 2516, One Knollwood Drive LLC, 830G site plan application for 72 Reservoir Street. Before the applicant or the applicant's representative come up to speak, if you haven't had a chance, you wish to speak from the public, please come up and sign your name. If you're online, please type a note to David so we can get you guys in the queue as well to speak after the applicant has their chance to speak. Anyone here? Oh, anyone online?
I'm not seeing any hands raised at this time, Mr. Chairman.
All right, the floor is yours, Mr. Marcus.
Thank you. For the record, Neil Marcus, Golden Wolf PC, joined by Josh Panero, who's behind me here, my partner, and we're here on behalf of the applicant, and we're following up on the discussions that we had on the 25th on the 4 grounds that we were trying to address with modifications to the plan to address the issues of denial. And to that extent, you should have a letter from Steve Trinkus dated November 15th. And that should address, actually, there are 2 letters from Steve. You have a set of plans from Steve that I sent to you, which modifies the location of the buildings and addresses the snow removal issue.
Do we have those that we can pull up on the screen? At all?
I hope you did.
Mr. Chairman, this is Steve Trinkus. If I can share my screen, I have it right up in front of me.
Okay, perfect. David, can we give Mr. Trinkus the ability to share his screen?
Dave,
Yeah, he can share his screen, Mr. Chairman.
Okay, please, Steve.
Yep, okay, give me 1 second here.
Sorry, Mr. Marcus, just wanted to have that on the screen while you were talking.
That's good. That was submitted on December 4th. December 3rd from Steve.
Can you see the AutoCAD file?
Yeah, we can see your CAD file.
All right, and maybe, let me address this, what we did with the buildings. Steve Trinkus, professional engineer for the record, representing the applicant. We reduced the spacing between the 3 buildings, between the northern one, the next one south, and the next one south, which then allowed me to increase the setback from 3.3 feet between the northwest corner of duplex 1 to the property line to a total of 8.4 feet. So almost 3 times, what it was. The building corner is also almost 19 feet back now from the edge of the pavement. So the sight lines are nowhere close from Knollwood Drive looking west. They're nowhere close to the building corner at all.
Okay.
Steve, while you're there, can you indicate on the map, at the last meeting, Mr. Murphy, I believe, was worried about his sight line.
Yeah.
And as a result of moving the buildings and prior to moving the buildings, could you just run through the sight line that you measured from his driveway?
Yeah. During the initial application for this site, we did show the sight line from Mr. Murphy's driveway looking to the east to the westbound lane on Reservoir. And that's actually always been within the road right of way. It does not even cross our front property line because you're looking to the north lane of Reservoir, not the south lane. So that site distance is, 250 feet or a little bit more, and it's completely within the right of way of Reservoir. So it's not even coming onto our property. So, it's clear because it's all lawn in that area right now, and that will remain lawn in the future.
Thank you. And other than that, what, in terms of snow storage, we went through this at the last meeting. We did an analysis of the average snowfall in the town of Bethel for the last 5 years. And then you measured the area where you're showing snow storage. Could you point out on the map again so it's clear? Where will there be snow storage?
There's,
for
well,
my-
starting on the north end of the site, between the stormwater gallery system and Knollwood Drive, there's an open area right here. There's also two smaller spaces between the driveways between duplex 1, duplex 2, duplex 2, and duplex 3. And if these, and this assumed that there was no compaction of the snow, which does occur every time you plow it, and also does not take into account the fact that once stockpiled snow is sitting on the ground actually thaws if it did have frost in it, and the snow underneath will actually melt while it's sitting there. If these areas are not large enough, the snow will simply be taken off site and disposed of, which is a common practice in many locations, throughout Connecticut.
And we would ask, and we proposed to council a special condition of approval requiring that the property owner would remove any snow that exceeds the snow storage that's shown on front part of the buildings on the site plan. We had some discussion at the last meeting that we could store behind the buildings and, pile up snow back there. There's some question as to doing additional drainage studies because as the snow melted, there's a question where the runoff would go. And we decided for simplicity that and given the fact that we've had such infrequent snow, and I say this, and if you watch the national news for the last week, all you do is hear about the horrendous snowstorms that are coming across the country. But knock on wood, we've been so far. But even in spite of the national news, we're going to take the chance at our expense, at the applicant's expense, that if additional snow storage is required, it'll be trucked off site. And that's a condition we're asking for. And that leads us down to one remaining issue, and that is council, Melanie O'Brien, has raised a question as to who has the rights to what is shown as the expanded shoulder at the end of Knollwood Drive. And it's been determined, as she's indicated in her letters to you, that Knollwood, which was a subdivision that was approved in 1969, that Knollwood was never formally conveyed to the town. And again, there are a lot of subdivisions of that vintage where people just forgot or didn't get around to signing the deed and holding the town meeting to accept the road. So Knollwood, we're convinced, I agree with Melody, has never properly been deeded or accepted by the town. And that was just about 60 years ago. In the interim, Knollwood has developed as if it's been a town road. The town lists it on the state records as a town road. The town plows it, the town repairs it, and the town has issued enormous numbers of curb cuts for the houses. All of those were across the shoulder of a road that was never conveyed. And again, Melanie, in her letter to you and in the exchange of our letters between each other that are part of the record, we've indicated that a road can become a road by implication, by usage. There are all sorts of ways that a road becomes a road without the formality of the deed. And we've all agreed that Knollwood falls into that class, that everybody has the right to pass and repass. All the curb cuts that were given to the other houses over the years were all fine. But because there's the extra wide shoulder at the mouth of the road on both sides of Knollwood, there's a question that town council has raised as to whether we can consider that part of the town road. Now, I'll tell you that it's been my opinion, and we've given a lot of facts in court cases, treatises by Judge Fuller, the planning regs of the town of Bethel, which say that you can't deny access to anybody along a public road with a reserve strip. But the question is this some sort of reserve strip to which the Diorios have no right to cross? Now, on the other side of the street, they actually developed property and got a conveyance from the town, and that's in your records too, a copy of about a 10-foot strip for drainage and to cross over onto the travel porch of Knollwood Drive. So on the one side of Knollwood, Town Council Martin Lawler at the time, First Selectman Matt Knickerbocker at the time, gave a quitclaim deed saying any interest that the town has in this shoulder we're conveying to you, which was used as part of the houses on that side. But on our side of the road that's in front of you today, and on that side, we are in a position where we have a new town attorney, we have a new first selectman, and we have the same circumstances that Knollwood was never properly conveyed. And we seem to be hung up on how to satisfy it. I have proposed that the applicant would take as a special condition of approval that we will hold the town harmless and defend against anyone who says that we don't have a right to cross this piece of shoulder to get to the road. Because I'm not sure, quite honestly, who's ever going to do that. It would have to be somebody related to the late Frank O'Brien, who was the original subdivider, who would come along and say, no, that was never included in the road that was developed as Knollwood. A, I don't know who that person is. B, it's a tough argument to make after all these years to say 60 years later, I own that shoulder and I control it. But if that were to occur, the Diorios will defend that claim. As of this afternoon, in my discussions with Melanie and with Chuck Anderson, Chuck is on the phone, we have not come to any conclusion on that issue. And the way that the Melanie and Chuck want to phrase it is a condition that everything's approved with a condition that we can't start construction until Melanie, the town council, signs off that we have the right to use the shoulder, which is a problem, I think, for all of us. A, it's an open-ended condition. Our condition is we'll just indemnify. We know what we're going to do. If somebody sues, we're going to spend the money to defend it, and we're going to win it. So at this point, as of about 5:30 this afternoon, the three council on the phone agreed that we need to find out from Melanie what she thinks is reasonably required to satisfy her that we can cross the shoulder with the driveways and do the work that's shown on the site plan. So to that extent, if you're satisfied that we've moved the buildings, addressed the site plan and the snow storage, then if you're in agreement that that meets the reasonable requirements of the amendment, then we're going to ask to hold open this hearing, much to my remorse because I wanted to resolve this once and for all. Hold it open until your January meeting. And during that time, Chuck and Melanie and I will continue to come up with language that deals with this right of way. Now, when I say with some remorse, my clients really like this proposal that's before you, these 3 units in their duplexes, and they kind of match what's in the neighborhood. If we cannot get to Knollwood Drive, all bets are off. Everything we've done as applicants, you've done as commission, really goes out the window because the only access to the property is Reservoir Street. There's no question we have access. We have frontage. We can come in with a driveway. The problem is we can't build this project with that type of driveway. To enter the property from Reservoir Street and to put any type of reasonable multifamily housing, you got to do a fair amount of blasting off the top of the hill, and you got to put your building up on the top of the hill. And that would be a single building. It would have to be about 3 stories, and it would contain somewhere between 8 and 12 units. depending on where you put your parking, et cetera. But as I said to both Chuck and Melody, we don't really want to do that because we've invested so much in trying to come up with a plan that makes sense for the neighborhood. Even though it's an 8-30G, it fits in. And I said, and some of you will know that there's a property up on Taylor Avenue that Tim Draper built, which was built under the same circumstances. A lot of rock, high up, had to do an enormous amount of blasting, had to build a large building that contains, I think, 18 units, 6 on a floor. And it sticks up on Taylor Avenue, but across the street are industrial uses. I mean, you got Worth Construction in their yard across the street. And so you could say it might not be in keeping with the rest of Taylor Avenue as you go up Taylor Avenue, but it is more like the industrial side of the street. That doesn't occur here on Reservoir in Millwood. If we have to come in Reservoir, we're going to change the character of the look of that neighborhood, and we don't want to do that. I'm not saying we won't do it, because I don't want you to come play this tape back and say Attorney Marcus says he'll never do this. That's not true. We don't want to do it because this is the better plan. But I've said to Chuck, he's here, I've said to Melanie, if we cannot come up with a reasonable way to use the access that we've shown, then we have no choice. So at the moment, I'm going to ask the commission to give us a ruling on the 3 items that we've addressed and tell us that will be satisfactory. And then we will continue the hearing if you see fit and address this 4th issue. And I'm confident we can come up with a solution because quite honestly, the thought that Knollwood Drive doesn't include the shoulder is hard for me to accept. And the thought that we could not build the type of housing that's more consistent with the neighborhood is really hard for me to accept as well. So I think we'll come up with a solution. But as of tonight, unless Chuck surprises me and tells me based on our 5:30 phone call, he's changed his position, and I don't think he has. But if he surprises me, I'll be happy. Otherwise, I think we're going to have to ask to have a little bit more time on that issue. That's where we are. That's our presentation.
All right, before we come to the public, I'm just to piggyback off of that, Attorney Andrews, if you'd like to, any comments you'd like to make on that? You're muted there, Attorney Andrews.
Certainly, Chuck Andrus, attorney for the commission. I agree with Mr. Marcus. We did have a conversation. Melanie and I and Mr. Marcus did speak this afternoon, and I appreciate his consent to the extension and waiving any claims that we would have to have decided this by this meeting. That's, and I understand you're not going to be asserting that's part of the 830G, but that is correct. I do disagree with some of the characterizations by Mr. Marcus. The issue, I mean, this is not simply a shoulder of a road. It is, if you look at the original subdivision, this is it's a very extensive area for which the applicant is proposing excavation, grading, utilities, blasting, and he doesn't own the property. The town doesn't own the property. The town, we as at least of now, doesn't even have an easement on the property. And so the issue is, what right do you have to conduct these activities on land that you don't own, the town doesn't own, that's not part of the present paved highway? So anyway, they're interesting issues, and I'm hopeful with Mr. Marcus that there is a way to resolve that and that we have sufficient time to do that. I just wanted to mention for the record, I'm not exactly buying into Mr. Marcus's characterization of the issue 100%. I do have one question for Mr. Marcus. I mentioned this in a phone call. One of the conditions, we gave conditions for denial. A condition of approval, either if we approved it last time or this time, regarding a recommendation by the health director, and it relates to acid rock drainage, which has been a problem in the past, if there are any wells within 1,000 feet of the premises. And I think Mr. Marcus indicated that would be a question for Mr. Trinkhouse, But I didn't know if you had a chance to look at that. Again, this would be something, there's a DEP blasting protocol that you need to follow that it's come up in other cases, but I didn't know if that's an issue. Perhaps you can, even after this, between now and the next meeting, address, provide information about that.
Yes, Mr. Trinkhouse.
Yes, Steve Trinks for the record. Laura has brought this up. She brought it up on Shelley Road for Mr. Draper. During the hearing on this application, we had Dave Ambrusco, who is the blaster for Mr. Diorio, who said they would put seismographs on the property lines and have 0 readings. If you have no vibration at the property line, you're not damaging anything beyond your property. I only found out about the well question today. I believe all of this area, the immediate area that would be closest to the blasting, is all public water. But also the fire marshal is in charge of the blasting, as we said on Taylor Avenue for the Oreos. It's a 250-foot radius outside your property for pre-blast surveys. We're not aware of any wells, but again, the blaster, stated on the record that they can have a 0 vibration reading at our property lines in the removal of the rock. So it doesn't matter what's beyond it. There's no impact. If there's no vibration, there's nothing.
The short answer- the short answer to your
Mr.
question-
Chair, can I add a comment?
Go, please.
We'll address it.
Yes, I appreciate Mr. Trinkhouse providing the information. If there are any properties with wells within 1,000 feet, that's the information that would be helpful. What we're talking about is not something that the health director made up. It's a DEP guidance document that she's relying on. In any event, we don't, all the information we need at this point are there. I think Mr. Trinkhouse believes there aren't, but if you could confirm that would be great.
Well,
And by the way,
all due respect, Laura's got to confirm that because she has the records
yes,
of every property in Bethel, to the extent that, the health department kept records. I do not have the ability to walk on anybody's property. So she would have to go through her records to determine if there are any wells within 1,000 feet of this site.
Well, Mr. Trinkhouse, you just made a representation that you thought was all served by public water. If you could provide whatever information you have on that, that would be great. And we could ask staff to look themselves as well.
And Chuck, just again, Neil Marcus, the town has records of where they're serving houses with a water system because they built them. So we can look at that. Laura hopefully will have some records of where the wells are. And the answer is, in any respect, the condition of approval, the general condition of any site on which the blasting is to meet the DEP guidelines, period. And you got to. So, we're going to do it one way or the other. But we'll also try to get the information.
Please do, because it sounds like
Thank-
we're
thank you, Mr.
and if we can have that information, it's gonna help us.
Yeah.
As the commission, the next hearing. So, before we move on, I know we have some members from the public that want to come up and speak, and also get some commission comments too. So we have, Scott Murphy, please, 74 Reservoir Street.
Scott Murphy, 74 Reservoir Street. I was noticing on the map that Mr. Trinkhouse put up, there's a pile, it looks like a storage pile for dirt and rock. Kind of on the corner where Mr. Marcus said they were gonna put the snow. How long would that be there? Will that impede the sight lines for Knollwood as well as, they moved the house as opposed to moving the sight line to the middle of the road? The other thing I just want to put out for public record, when the property was sold to them in 2017, it was an R40 single family home. I don't know at what point it was changed after that. Obviously, I'm going to say it was for this, to put multifamily housing in. It is a small lot. I appreciate the work that they have done to make it better for the neighborhood. Although the neighborhood is already well packed with people. The road's only about a half mile long with 5 roads off of it, and three of them are dead end roads. So all the traffic is still, so 6 cars like they're proposing, we all know that multiplies into 12 and 14 and so on down the road. But I appreciate the work that Mr. Marcus has done and that the Diorios have done. My only question right now is that pile of rock and dirt they're going to store, is that going to be there for the duration? And how much blasting will there be, and how, is this pile going to be an obstruction?
That's a very good question. It's a fair question. If we could have that, if you don't have that answer now, Mr. Trinkus, it sounds like I said, if we have the meeting open for next week.
Oh, I can answer it right now. It's a temporary stockpile during the excavation period of leveling the area for the development. And based on a discussion I had with Mr. Diorio about the Taylor Avenue site, is actually, they're not going to process any material on the site. They will be putting it in trucks and taking it to their yard. It's a temporary thing. Once the blasting is done, there's no dirt there at all. So it's back to being, the lawn that it currently exists.
Do we know how much rock has to be blasted out?
We provided that during the other hearing. I don't have it, but it's in your record, but I don't have the number, on my fingers right now. But we did provide that during the original application at one point.
Okay.
I was just wondering if it changed because they're moving.
It has been there, and then unfortunately, we do have to kind of keep this discussion
Well, no,
to the
moving
reasons of
structures.
denial.
I didn't know if
We have
they
to
had
keep that in
to.
mind.
No, the Steve Trinks again, the limit of blasting did not change. We just reduced the spacing between the 3 units, but the limit of blasting on the southern end of the site did not change at all.
Okay, appreciate your work.
Thank you. We'll open up to commission comments here. Mr. Legnar, we're starting with you online. Oh, we have a Gabriela Hernandez. I'm sorry. Before you get there, Bob, would like to speak about 72.
Yes,
Please, go
hi,
ahead.
Gabriela Hernandez, 114 Hollywood Drive. A couple of questions. One, where is that yard where the excess rock are going to be stored while construction is happening? Like, where actually is that yard?
It's on Payne Road.
Okay. Also, comparing the two options of the 3 duplexes compared to the 3-story building you mentioned, which one of those options would blast less into the rock?
This option, the 3 units, the 6 units at the bottom of the hill. If the units go up on top of the hill, we have to level a much larger area to a greater depth, so there'd be more blasting up there.
Right. So, in my opinion, based on the least disruptive option for the natural surrounding, I think the 3 duplex option is better, because, again, limiting the amount of green open space that we have isn't something I support. So the option where it is least disturbed, I definitely support. My last question is about the driveways. And so the question is either having a driveway entrance on Reservoir or having 3 driveway entrances for each duplex on Knollwood Drive. What's like, I guess I'm not really understanding what the issue, if it's comparable to the builds that are directly across the street, how is that different on the other side of the street?
The 3 units cannot be placed within our property if they were to face Reservoir. There's not enough width of the land to put them that way. I did look at scenarios where 2 were that way and 1 was off Knollwood, but it actually required that the limit of blasting actually went further south to make it work. So if we have to come off Reservoir, as Attorney Marcus mentioned, the option is we go up to the top of the hill and we level the top of the hill. The area that, we're not touching based on this plan is roughly 15,000 square feet or a third of an acre of woods that's going to remain, just for the record.
So why wouldn't the driveways fit? Is it just because the street is not, labeled a specific thing?
It starts to pitch down in the back end of the site. So you don't, if you were to flip the buildings and go the other way, you don't have the room to get the driveways into those last units. Hence why they would have to put them on the top of the hill and blast more of the rock up there.
Right. So I guess as a Knollwood resident, I don't see the issue of the driveways being on Knollwood, other than it will add more cars. And it may impact the line of sight where people park. But again, if the drive is in enough on Knollwood, I guess it shouldn't be an issue. Okay, thank you for your responses.
Thank you. Okay, we'll open again back up to commission comments. We'll start, Mr. Legnard. Oh, we're muted here. Bob, you're I think we muted you. We muted everyone before. Do you know how to unmute? There we go.
Okay, I have one question of Attorney Marcus or Steve Trinkus. There are no utilities presently in that piece of property in question between the Diorios and the town. Is that true? There's no drainage or anything in?
No, yeah, Bob, Steve Trinkus, there's drainage, sanitary sewer, underground, power cable, telephone, all on, Knollwood, within the right of way of Knollwood.
But is that on that side of the road or the other side of the road?
Well, the sanitary comes right down the middle of the road.
Okay.
There's
That
actually,
shouldn't be affected by the ownership of that property, right?
no, and the drainage line is within the pavement. The underground utilities are located west of the traveled way. It probably in the flatter shoulder that exists there at the southern end of in front of the duplex unit 3, just in the right of way towards Knollwood is where the utility box is for that. The water line is also along the eastern side of Knollwood, obviously under the pavement. So, all the utilities are pretty much in the road or just west of the shoulder.
So it shouldn't be complicated to get this thing ironed out as to who to own that piece of property.
Yeah, that's from Mr. Marcus.
Yeah. The answer is, Bob, it should not be. I appreciate that. It's not.
Okay, and secondly, I'd like to make sure we're on record again with the blasting. I know in the previous public hearing and in this one, that special care be taken of Scott Murphy's grandson.
Yes, the blaster.
It could be a problem, and we'd like to make sure it is not a problem somewhere down the road.
The blaster said he would take every precaution that the Murphys would want when we do that.
Molly, any questions?
No questions at this time for me. Thank you.
Kenny?
I think the legal thing is clearly a serious thing, so clearly we can't move forward until that's solved. And I'm glad that you moved the buildings, moving in the right direction. That's it.
Eric?
Two things. First is about accountability for the snow. So I feel like as we sit here today on December 9th, it's a wonderful offer that, in the event of excess snow, it's going to be transported off the property. I worry about what that looks like down the road, right? And what kind of accountability is baked into that when we do have a big snowfall and we don't have any place to put it. Who's kind of keeping tabs on that offer, and how long it lasts? I mean, is that an offer in perpetuity as long as the property owners are the property owner, or what happens when
It runs with the land, gets recorded. It'll
Okay.
run with the land.
Okay.
So when you buy it, you move the snow.
Okay.
How is it enforced? How is it enforced if somebody's not?
I believe that'd be a zoning violation, right?
Yeah.
Just like any other
It would be.
zoning violation?
Yep. Yep.
There's a man who's gonna take care of it.
Okay.
It's David's problem. But yes, it would be a zoning violation.
Okay, thank you. And then just kind of a general comment about blasting. I feel like there's kind of, I hope I can articulate this the right way. I hear a proposition of two different projects. One being an alternative measure should the property line on Knollwood not be able to be established, right? Coming in from Reservoir. And it seems like there's some sort of kind of tacit acknowledgement that worse because there is more blasting that's involved, more rock removal, land removal, etc. At the same time, I hear Mr. Trinkus talk about how blasting is so insignificant. It doesn't even, we don't even pick up on the measurements, right? As though it's not an issue. So I feel like it can't be both things, right? It can't be, well, this is better because there's less blasting and also blasting doesn't matter. So I think that people are concerned about the blasting. I am too, and I don't know if our minds are put at ease.
Can I address that?
Please.
Blasters are the most misunderstood people
Well,
since my wife.
On the record.
She has to do.
Not watching.
But the fact of it is, people don't understand blasting. I got to tell you a quick story. Up on the top of Good Hill, where there's a lot of rock, the late Costa Sturgeon, my client, she was sitting here one night at the meeting, and there was everybody was yelling, "No blasting, no blasting." And Costa agreed to a condition, no blasting. And when I thought he completely lost his mind, and we walked out, I said, "Costa, how do you deal with all this rock?" He said, "I'll use a drop hammer." And guess what? If he used the drop hammer, all the neighbors would call the next day and say, "Could you stop the drop hammer and bring a blaster in?" Because, blasting is not as toxic as it used to be. We all thought about blasting from watching Cowboys and Indians on the TV, where they would dynamite the train and blow it up. That was blasting. These guys don't do it that way anymore. You measure the rock. You have a defined diameter of a hole. You pack it with enough explosive to just loosen up enough. You don't blast it into the air. You want it all to stay in place. You have blasting mats. Anyway, if you ever saw blasting, you would understand it is not as toxic as you think. But what Steve and I are saying, that the more blasting you do, it's not the blasting, it's removing the rock. It's the truck. It's the trucks full of rock leaving the site. Or absent that, if you're going to process it on the site, it's the days of excess processing that you're trying to avoid. So blasting itself is easy. It's expensive, but it's easy. But it's what you do after you blast that changes the nature of the construction project significantly. And that's what we're talking about. And then our real concern is that the shape of the lot changes the building significantly. And so and again, we got to figure out how to get into the site off of Knollwood Drive, because that's the only place that makes real sense for everybody.
Jeff? Mr. Triggus, how far are the buildings apart from each other now? Or how far were they apart and how far are they apart now? Oh, he's on mute. I don't know if he's trying to speak.
Steve, you're on mute.
Sorry. Yeah, there was originally about 9 to 10 feet between the buildings. I took 3 feet between 1 and 2, and then another 2 feet between 2 and 3, because these units do have windows on the sides. So but that extra 5 feet is what went from 3.3 to 8.4 basically. And I'd also say, during the original application, in your record contains testimony from the blaster about how they do it. And Neil is right. What they do now is they break it up. There's 6 foot center to center spacing, and they're small charges, and they crack the rock basically in place. They do use mats, but they crack it. It's not blowing up in the air. And then they excavate it out. That's the way the blasting is done today. It's a far cry from what I remember watching as a kid in my neighborhood in Reading, when one of my neighbors was building a new house, and they drilled it, they put the mats on it, and the mats flew 15 feet in the air. You don't do that today. You're cracking it in place. And there was a whole discussion by, Dave the Blaster, in the original record. So
the distance is 7 feet now after
Six.
Yes.
that dissertation,
Six.
we're
Yeah.
down to 7 feet.
It sounds like 7 feet on average.
6 to 7.
Don't do
No,
that.
seven
Don't
across,
do that.
because he said it was
He
9
took
and 10,
3
and
from
he's
9 and
reduced
10.
2 and 3. So 9 brings it minus 2 is 7, and 10 minus 3 is 7. So
Yeah,
it's
7
7
and 7.
feet,
7.
7 feet. So my question
Seven.
then, sorry to piggyback on you, Jeff, is that distance acceptable to the fire marshal
Or building code.
or building? Well, it's a 830G, so building codes are.
Nope, building
that's
codes
not
do
bad.
not
Nope.
get thrown out the
Building
window.
codes is-
Planning and zoning
So
does.
then is
It will be
that,
reviewed by the building department.
Less than 10 feet is going to require a fire.
Yes.
So they will require a firewall on each side of those buildings.
And fire windows.
Correct. Yeah.
And the
So
fire.
yeah. They're like, 7 to 8 foot. Under 5, you do have to have a firewall. Mr. Draper ran into that on Nashville. But yes, if the exterior wall has to be, the fire rated wall, it will be. But that's why I only took, a total of 5 feet between the two of them, just increase that setback to the front property line.
And why couldn't we just take the existing configuration and slide it south? That's kind of what I'm expecting.
It would push up a deeper rock cut, because the rock cut moves up to the south. And also because of how the driveway is located, the right of way, where it's wider, then all of a sudden, just about where unit 3 is, goes back in a northeast direction to hit what is really the typical right of way limit, which is, roughly 12 feet off the pavement. So there's this triangular chunk there that if I move the building further south, I can't get in the garage.
Got it.
That's what I said, 9
Okay.
units.
Yeah, right. So 2 buildings would fit perfect. To address the snow issue, you have the storage area is in the north of building number 1. It's actually in the town right away. It's not even on your property. And I have a feeling it might encroach into the sight lines. Maybe the snow wouldn't, and there could be a condition of approval that it's got to be X amount of feet from the edge of the driveway or it's in violation. But I do see on the stockpile location for soil and blasted rock, there's a silt fence that runs right up almost to the edge of the road. You would think that the pile would spill over right to the edge of the silt fence. That's clearly in the line of sight. So that silt fence would have to be brought back so it doesn't get into the line of sight, even if it's only temporary. You can't block the site on any day. So that again could just be a condition of approval. And Neil, I do think that the issue with the title of the roadway or the right of way is a bit of a bigger issue because we're developing that area. Like this is our driveways. This isn't ingress and egress over a cut curve to get from the edge of the drive to the 12 feet past the right of way to our property. We're actually parking here and living in this space. So I think that's maybe what, I don't know, I'm not going to speak for Charles Bellamy, but to me, that seems like why this is a little bit different than your typical 50-foot wide right of way. Town takes care of it. Boom, we bust off the curb.
13 feet on either side of the paved portion.
Right,
would be really
right, when they
easy.
put the
I
road in the
agree.
middle.
I agree with you, but, on the other hand, after 60 years almost, nobody's claimed this right away. I mean,
I see your point.
that's a really.
in that. It would have to be the original landowner.
And I'm gonna try to find them. I mean, I'm gonna see the rules.
Terry might know.
Who knows old time Bethel? Did anybody know the O'Brien family?
Barry O'Brien?
He was a developer, right? Yeah. Are they still around?
I have no idea.
If you don't know.
Yeah. This came up just very recently, actually, up on Maple Road near the Berkshire area, that the Steiners ran into a similar problem. There was a piece of road up there that the original owner had not deeded to anybody. And they went to court and actually did a simple quitclaim with the help of the town to get it, researched, tried to find the person.
Quiet
We're able to
title,
get it
yeah.
on quiet title,
Yeah.
right.
That's an option.
That's what they did, and it worked fantastic for the Steiners just recently.
I recall that we had to do a, what was that? What's that called when we, let's see,
Eastman.
property?
Those are those notices in the paper to the heirs and descendants of Harry O'Brien that you see every once in a while. Those are the quiet titles that are lost.
Jeff, anything else?
Yeah, a couple more things. I'm still a little hung up on the snow storage. You have 2,000 cubic feet between the two buildings. 7 foot wide. I'm making assumption the buildings are 40 feet from the edge of the drive to the back. You can correct me if I'm wrong, Steve. That's a 7.5 foot tall pile. So I feel like that's an overestimated number, that you're going to put 7 feet of snow in between, packed wall to wall between the two buildings.
That's not correct. I said we're putting it between the two driveways, not between the two buildings. It's not going between the structures themselves. Also, that's assuming we get one big dump. Is the weather data I got was from Jack Drake, who's a local weatherman for the past 5 years of the snow in Bethel, and we averaged 20 to 25 inches, over 5 years. And I know it's been a snow drought overall in New England, but this is saying if you had 20 inches fall at once, you could do it. We haven't had that happen since back in 13. So if there's 3 inches of snow, it's going to get plowed over there. We get some warmer weather, it starts melting and it's available. Plus, snow compacts. 12 inches of snow can compact down to about 3 inches simply by plowing. And the other, important issue is when any town plows the road, the snow banks are right along the shoulder. And I will tell you, back in 13 on my road, because we had a lot of snow that year, the banks along my road were about 5 foot tall within the right of way. But, luckily I'm on, a relatively flat road, but it literally blocked the sight lines, and it's from the town plowing. So that's a common occurrence on any road when we have a significant snow year. But the point here is, if we can't store it on the site, it gets taken off the site. That's what the shopping centers do. That's what, I know Mr. Draper has done for, his affordables. So, it's a common practice.
They do it down Griffin Avenue.
Correct.
Yep.
All right, lastly, your proposal to put a driveway in from Reservoir. I mean, we've been talking about site distances this whole time. You wouldn't be able to put a driveway in off of Reservoir.
Oh, actually, we could.
It's 125 to the top of the hill. You could put it in the middle.
We would come in about the middle of the site, which is at 388 contour. You have a 390 going to the west, and then it starts pretty much being almost level. It's 388 west of Mr. Murphy's driveway. So the site distance would actually be very clear along Reservoir. And I need to point out, because I think it got lost during the hearings, is when I initially did feasibility plans here, we were, for the Diorios, I did have the driveway coming off Reservoir with the units up on top of the hill around that 10 to 12 that Mr. Marcus talked about. And we went through multiple iterations. And then Mike Diorio met with Beth, your former planner, numerous times. And this is the plan recommended by your former planner. This is how we got to this stage. But I had many other layouts that had, apartment style building with 10 to 12 units, in them, coming off Reservoir. So those are some of the early options that we looked at.
We'd like not to do it.
Anything else, Jeff?
Yeah, I find like that would be a struggle, but, no, nothing else.
Any questions?
I do not have questions.
Sproul, anything else?
I commend you from last time. You've made good progress.
Thank you.
I appreciate the tone, and the progress. I do have a concern on the snow, which Jeff, I thought you did a good job there at opening the door on that. And that is, it's nondescript. At what point does it become the alarm runs and, okay, we have to go and remove it? I have a week of no snow, followed by a week of 2 inches every day, followed by a 10-incher. At what point does it trigger? Do you have a proposal that says once the annual snowfall reaches X, from that point on, we start removing? Or how, because otherwise it's nondescript.
Yeah, I'm gonna make a suggestion. We could put in there, as you just said, as a condition of approval, if the annual snowfall in Bethel exceeds 20 inches. But if you get a 14-inch snowfall followed by a month of defrost, basically a month of melt, then you get the next 10-inch snowfall. You might have no problem storing it. You've already have 24 inches. So I think if I understand what you're saying, the better way to do it is
With all
give
due
us a
respect,
condition
this is,
of height.
you might or
No.
you might not.
Give us a condition of height. We'll store snow, but no higher than
But
5 feet.
what's he proposing in that 2,000 cubic foot area?
Steve, how
is
high
it?
will the banks be if we have 20?
Well, the banks start on grade and they go up kind of in a triangular fashion, and it was about 4.5 feet of snow.
Good.
In those areas. But
That's
again, if the owner places snow in these areas, he has to take it off site. That's the simple, what they're gonna do here. It doesn't matter how the snow shows up. If it can't be placed on the site, it has to go off site. That's it. That's the way it.
But I wanted, but school wants a number, and I actually agree with him because he said nice things about it.
And it's enforceable.
Yep.
And it's not, oh, well, no, last week the snow compacted because temperatures dropped and then we had rain and we had more compaction. Then we get into this back and forth. Just give me a number. If
5
it
feet.
exceeds
Not to exceed
25,
5 feet.
5 feet total?
For height, 60 inches, you can't store snow.
Not 5 feet of total snowfall.
I'm talking snow.
No, I'm talking
Yeah,
about
it's a harder thing to do it that way. I get that, but no, I think the snowbanks can't be higher than 4 feet, 5, whatever the number is.
I say 5, Jeff says 4.
Well, what's when
It's
you're sitting on your
4.5.
car?
Yeah.
If I say something nice, it'll be
50, it's 54 inches, and that is measurable. You can stick it.
So
I would do that. I would make that the
That-
condition.
we should make that
we will make that a condition of approval when we get to that point, after we have all the legalese figured out. Hopefully between now and the next hearing. But I do, before we kind of continue this to the next public hearing, I do want to say thank you for working with our suggestions of the last meeting. I will, again, for the record, say I think 5 units would solve a lot of issues. I will continue to say that, but I do appreciate you guys taking into consideration the sight lines and the snow removal here. So this will be continued to our next public hearing here in the meeting room on January 13th. Do we need to get a letter of, so we'll work that out. You'll get a letter
And I will
of
send you a letter, yeah.
of extension.
Yeah, a letter of extension.
Thank you.
Absolutely. That's easy to do.
Okay. Thank you.
Thank you.
All right, we will move on to our work session. So our work session, the first item is 5A, PZC 2517, Bethel Planning and Zoning Commission text amendment requirements when the commission initiates a zone change. If you guys recall, we did have a public hearing that we closed on the last hearing. It seemed like there was no objections to that. So if we can have some discussion here amongst that. And Jeremy, if you want to give a little bit background of that, and then we can make a motion to act on that.
Sure. So, as you'll recall, this came up as part of the TOD changes. We had that hearing, I think, back in August. Feels like forever and a day ago, but we discovered that the regulations required a license land survey, signature of a license land surveyor on any map that goes along the zone change. The map that was proposed at the time, obviously, didn't have that large area, it's a number of properties, it's impractical to do that. And so the idea is to just change the language so that the commission can act on zone changes without requiring a surveyed plan. It's been reviewed by your town attorney, your land use attorney, Chuck. The language is similar to that which is used in many communities across the state. We gave you that language for the last meeting. I don't remember hearing any public comment on that. We got some other public comment, which is our next work session. That's where we are.
Okay, we'll open it up. Bob, do you have anything you would like to discuss on that?
Good.
Molly?
Not at this time. I'll let you know if I do as we continue to discuss. Thank you.
Thank you. Ken,
I'm okay.
Eric,
All good here.
yeah,
Okay.
I'm also good with how, we have worded that. Anything else there? Scroll? Okay. I make a motion, that the Bethel Planning and Zoning Commission adopt the text amendment, requirements when the commission initiates a zone change, dealing with the issues that, sections 8.7B and 8.7C.
Second.
Second, okay, I'll do a roll call vote for that. Mr. Legnard,
Aye.
Molly,
Aye.
Ken.
Aye.
Eric,
Yes.
Jeff,
Yes.
myself, yes. Cool.
Yes.
Thank you. Motion passes unanimously.
Mr. Chairman, we do need a date for that.
Oh, sorry, we did say we wanted it effective.
I would say no sooner than January 1st.
Okay, so do I have to do a whole amendment?
I would amend the motion.
Okay, I'm gonna restart that motion. I'm gonna make a motion, that the Bethel Planning and Zoning Commission adopt the text amendment requirements when the commission initiates a zone change for sections 8.7B and 8.7C and make that effective no later than January 1st, 2026.
Second.
Second. Mr. Legnard,
Aye.
Molly,
Aye.
Ken?
Yeah.
Eric?
I,
Jeff?
yeah,
Yes.
excuse me, Ms. Chair, I would set a date, not say no later than, just set a date.
Oh.
Yeah, I think January 1st is fine. That's your date.
January 1st. Do we have
I
to do
didn't
that
catch that.
again?
You said no later.
Sorry.
No.
Do I have to say, I'll do it again.
Do it again.
I'll do it again. Do it live.
It's really the same motion over and over.
Bethel Planning and Zoning Commission adopt the text amendment requirements when the commission initiates a zone change, section 8.7B and 8.7C, effective January 1, 2026. Bob? Oh, second.
8.2. Yes.
Yes. Molly?
Aye.
Ken?
Yeah.
Eric?
Yes.
Jeff?
No.
Was that a no or I don't know?
I don't know. Yes.
Yes. Cool.
Yes.
All right. We good?
I think
I couldn't have done it. I had to have one hiccup as
You know, it's all right.
So, all good. Let's move on to 5B, discussion, text amendment to notification requirements when the commission initiates a zone change. I'll let you, Jeremy, give that background.
Yeah, so this came about at the last meeting during the hearing for the piece that we just approved. There was public comment on notification requirements when the commission initiates a zone change. So currently, the commission is exempt from notification of all the property owners within the zone and within the 500-foot radius of the zone change. And that is on purpose. It's because there was a public act back in 2006, I think it's 06-80, which states that commissions do not need to send notification when they initiate a zone change. And there's a simple reason for that. If you have the requirement that you send notification to those within the zone change and that 500-foot radius, if there's an error in that notification, even one, and this doesn't apply to public applications, but if there's an error here, your appeal period is extended out to a year, not 15 days. And so there's a pretty significant risk there. I mean, especially when you're dealing with large areas, if you're dealing with an area, let's say you're rezoning, let's take, for example, you take the R10 zone and you want to move it to the R12 zone, you're going to make those lot sizes a little bit bigger. If you put this burden on yourselves to notify everybody within that zone that's going to be affected and everybody within 500-foot radius of that, and you miss one notification, your appeal period is. So I would caution you against doing that. I would strongly caution you. Now, that being said, if there is something that you think is, something that you're interested in notifying neighbors on, you can always request that staff do it, but that won't trigger the appeal period because it's not a requirement.
So we can make it our standard practice that when we do a zone change as a board, unofficially, we will request staff notify.
You could. It's a heavy lift. It's expensive.
Understood.
It's, there's other ways to notify that aren't mail. And I think they're effective based on, the number of folks that showed up to that TOD hearing that we had a while.
Do we, I don't expect you to know, but maybe you do, for the example, the TOD zone change, do we have an idea of how many notifications that would be?
I can look.
While you look,
We could control it on a case-by-case basis.
yeah, Bob, what's your thoughts? You think it should be more of a,
Well, I think you can control whether or not you notify the general public or a certain group of the general public on a case-by-case basis instead of making it a blanket thing all the way along the line where you have to do it every single time.
Well, how did everybody find out about the TOD modification? Public notice?
Facebook?
Thanks.
Yeah, we did the News Times and
It's on the website too.
yeah.
How do you know everybody did find out?
Right,
I
you're
didn't know
right.
that.
You're not wrong.
Everybody who showed up.
Although it is a work session, so I'm gonna have to ask you.
Oh, sorry, I'm sorry, you're right, I'm sorry.
Sheriff.
Molly, do you have any comments on this? I know you're getting your feet wet.
Looking at the notes from the last meeting, and you know, hearing what was just mentioned about the not making it a written requirement to allow for more flexibility in terms of any appeals that occur. You know, I think that should be something that we should take into consideration. Maybe keeping the current language and going on an as-needed basis may make more sense.
I agree.
Yeah. Eric? Yeah. Jeff? That is an interesting piece of information. 15 days to 365 is a big difference.
It's a very big.
And it could delay things over and over and over again. Correct.
Especially when you take into consideration the cost, as was just mentioned, of if we're mailing these and if we miss someone, that's something to absolutely consider in terms of the amount of staff work and time and cost for getting these messages out to individuals who may be affected.
Any comments?
Dan can put it into his weekly newsletter.
I'll go along with the majority here.
Yeah, I boy, that,
That 1 year thing.
I was really all in favor of doing this last meeting. But the 1 year appeal period and how that affects everything does make a change. And I think, at least for the foreseeable future, if I'm the commissioner, I'm always going to recommend we do that. But to not adopt it as a official regulation, I think is, don't look at me like that, Amanda.
Sorry, because I'm the one that has.
I know.
So
I know.
You asked about the TOD, you know, and the notification, if we went with the requirements, the way it's written in there right now is it's condo owners, it's associations, it's everybody. And so for the TOD, that would be about 440 pounds.
Times how much?
$10.
Well, I mean, and I don't know.
Certified.
Yeah, if you're gonna do certified, it's about $8 a pop. If you do certificates of, which the statute was changed, so you can do certificates of mailings, that's when you get the receipt for it. It's a little cheaper, it's about $1.50, I think, but still, it's over $500.
Significant staff.
We're not doing it all that often, but I also don't want it, but let's just, for an example, if we did the TOD thing, as we move forward and we continue to amend that and make changes to it. Something happens, they appeal it for a year, then we go to do it and it's on our regulations and something happened again, now we're 2 years out before anything actually happens. And it's really slowing down our ability to come up with regulations that are effective.
I agree with what you're saying, but really, we're walking around with egg on our face anyway on this TOD thing, my opinion. Because we messed up one way or another, notices, we had a number of attorneys come and call us on the carpet, tell us what we had done wrong, regardless of the notifications. We don't do this, not even once a year. So we're talking about not putting transparency in notification, because maybe once every 2 or 3 years we engage in this activity. I'm not comfortable doing that.
Counterpoint, those same attorneys are gonna find every little thing we didn't do right.
Every time.
Every time.
Okay.
I think if you want to notify, I think you do it on a case-by-case basis as a recommendation, as a courtesy. I don't think you put it into your regulations, because that's where the appeal period piece of it
I
gets.
agree.
All right,
That's my
Yeah.
recommendation, and I told my,
I volunteer.
I told the rest of the staff at Tyke, we serve in this capacity about 25 towns around the state out of the 169. Nobody has that requirement.
Okay.
None of the 25 that we're serving currently.
Now, that's an interesting piece of.
And I suspect that the vast majority of the rest of them that we're not actively working in also don't have.
Sure. Well, I do appreciate the color on that, and I think just so we have a good, do a little consensus vote, if that's okay with the board. All in favor of just keeping it as a case-by-case basis? All in favor? Aye.
I'm sorry, do you mind doing it one by one?
Oh, sure.
Thank you.
Bob, in favor of keeping it as a case-by-case basis, yes or no?
Yes.
Molly,
Yes.
Ken,
Yes.
Eric,
Yes.
Yes.
yes. Okay, that's what we're gonna keep it as.
I want to keep talking about it. You want to move on?
We can do public commission comments later.
I mean, okay. What's our threshold for case by case and what? It's kind of like rules question.
We'll bring it up and vote on
I think that's appropriate.
it. Make a motion.
We can always do a consensus on anything we do.
Just
All
have
right.
to remember today.
All right, moving on to number 6, new business, 6A PZZ 2519, Eppoliti Industrial Inc., site plan special permit for 15 Great Pasture /0 Worcester Street. This is a new application coming forth. Is there any background on that, or?
It's an industrial site plan. It's an expansion of an existing facility that currently exists just north of the boundary line into Danbury. They own property in Bethel, and they're going to be expanding. That's the background that I'll give you at this point. I think at this point, we're looking for an acceptance and scheduling a hearing for the second meeting in January.
Sure. I'll make a motion that we set a public hearing for 1/27/26 for 15 Great Pasture Road, 0 Worcester Street, and recommend to all departments within the building for their review.
Second.
All in favor?
Aye.
Any opposed? Any abstentions? There you go. Moving on to business meeting. We have minutes. Did everyone have a chance to review the minutes of 11/25/2025?
Yes.
Does anyone have any comments about the minutes? No? Okay. I'll make a motion that we accept the minutes from 11/25/2025.
Second.
Second.
All in favor?
Aye.
Any opposed? Any abstentions? All right. We have a bill to pay for Hearst Media Group for $1,557.50. Want to make a motion?
Make a motion to pay the News Times $1,557.50 for public uses.
Second.
All in favor?
Aye.
Aye. Any opposed? Any abstentions? No. All right, keeping the ball rolling, we'll move on to number 7, adoption of the meeting calendar, 2026 meetings. Has everyone had a chance to review that?
Yes.
Does anyone have any requests of anything we make a change to? We're staying kind of consistent with our 1 meeting in August and 1 meeting in December. I think that's appropriate. And I think it's good. I know, Jeff, there's 1 or 2 that you'll definitely be the chair for.
Now.
Right. Does everyone make a motion to approve this calendar?
So moved.
Okay, do we have a second?
Second.
Second.
All in favor?
Aye.
Any opposed? Any abstentions? There we go. We'll move on to number 8, public input. Does anyone from the public wish to speak?
I'll take my turn whenever. Oh, that's gonna be now.
Please come on up.
Nancy Sudik, 2 Ridgedale Road. This is just a question regarding what seems to be a new policy or a new procedure. So do you have to always sign up if you want to make a comment? Because I didn't sign up to start with because I didn't think I would have anything to say, but then everything happens before it's time to ask questions. And by the time I heard what the attorneys, everybody was saying all that stuff, I'm like, Yeah, I could probably make a comment, but I didn't sign up to do it and it wasn't that important.
You are more than welcome to come up here after the fact. I think what we tried with, Paul tried to implement this a couple meetings ago, maybe half a year ago, is really just to control when we have a larger public
Well,
interest
that's-
hearing.
Sure, like
Where
a
we can then,
TOD.
when, you know, previous times, we just kind of say who's next and if someone raised their hand, they come up. This is gonna just keep a nice record of it moving forward. But if you're here and you have something to say, by all means.
As long as I wouldn't be excluded, other people wouldn't be excluded because it almost seemed like.
You do
I
not have to
sign
be
up.
on that list. Like, I think
Okay.
Gabriela Hernandez joined. She was not on the list and she had made public comment about 72.
Okay. All right, I just wanted to make sure. It was.
It's just to kind of keep it a little bit more organized.
Yeah, people would like, three of us are sitting here, it's like, really? Thank
No,
you.
understood. Thank you,
Okay.
Nancy.
Thank you.
Appreciate it. Does anyone online have anything they would like to add? Or have?
I'm not seeing any hands raised at this time, Mr. Chairman.
Okay, now we will move on to our executive session. So I'm going to, apologies, Paul did last time. What is our formality here? Do we have to make a motion to move into executive session?
Make a motion and invite the commission members, Attorney Anders, staff. And that's it, and everybody else has to leave.
Okay, so I will make a motion, that the commission enters into executive session for Vessel Technologies Incorporated versus Planning and Zoning Commission of the Town of Bethel. I'd invite all staff, present with us, including Attorney Anders, and staff online and in person, as well as all commission members, alternates, and full-time members. I'd also ask, that we invite, former member who was active on this, Paul Shanley, to join via Zoom. So I'm gonna just text him now if that's okay. So do I have a second on that?
Second.
Second.
All right. Second, there we go. We'll go, vote, Bob,
Aye.
Molly.
Aye.
Ken.
Aye.
Eric. Yep. Jeff. Aye.
Aye.
All right. Can we please close the public hearing?
And there will be a planner's report.
Yes,
The
yes, we
information
will.
will be on.
Yes. Thank you.
I brought a.
It is written and available online. Thanks, Chuck.
Thanks, Chuck.
I'll go see if she wants to come in.
All right.
David, is anyone out there to,
I just readmitted Diane Ryan.
okay.
All right. We, as a board, are out of executive session and no votes were taken, right?
Right.
That's the way it's said? Yeah, cool.
And the time is 9:10 PM.
9:10. Thank you, David. Moving on to number 10 on the agenda, planners report.
Sure. 3 items, they're written down for you there. There's an update on House Bill 8002. We talked about that last 2 weeks ago. There was a question about its impact on the efforts to get the moratorium application in. We don't have to worry about that until 2029. That provision that's in there that makes the moratorium, that's connected to the moratorium, has to do with the housing growth plan. We don't have to adopt a housing growth plan until 2029. Therefore, you can't be out of compliance until after 2029. If you fall out of compliance with the housing growth plan requirement, then you are not eligible for a moratorium, but we've got 4 years.
So we're not worried about that.
We're not worried about that. Training, as a reminder to you all, you need 4 hours of training within your first year after being elected or appointed to the commission, and then 4 hours every 4 years thereafter, or each term that you're sitting on the board. So just keep that in mind. I'm going to put together a kind of a one sheet for you all, just explaining the training requirements, and throw some links on there that you can look at. Clear is one of them. The Connecticut Bar Association does a big training every 2 years. Maybe some of you have been to that. That's the one where you get the big fat book. It used to be up at Wesleyan. Now it's online. If you do that every 2 years, you're covered. That gives you all the training you need. So I'll put that all together for you all in January. We've got a couple of new members. We've got some new alternates. So I'll get that out to you. But if you have done any training within the last year, let us know, because we're supposed to report that up to the Board of Selectmen on a yearly basis. And finally, I gave you updated information on the moratorium application. We are currently still working on gathering the compliance certificates. I'm happy to report that I have one more as of today, and a phone call into the office. I've got to call one of those developers back tomorrow. So hopefully that means 2 more. That's 4 out of 16 or so, but we're getting there. So we're
How many HUEs are related to those 4?
like 26 to 30-ish. Yeah.
Well shy of opening.
well shy, but you know, once we've got the compliance certificates, I think once we have all those, we can set this thing in. I think everything else is pretty much in line.
And I saw on there, like, we're projected at 195
Yes.
or 159 required.
Correct. Yep. Yep. So we've got some wiggle room. If there are a couple of developments that we don't get compliance certificates on, we've got some wiggle room. And we've established the process going forward so that we'll get these things annually. And if we don't by a certain date, it becomes a zoning violation that goes on the books. And I know.
And we will find them.
Yeah, I was gonna say, the Board of Selectmen is working on an ordinance to be able to find them. And, you know, I would make the argument that every day that, you know, it's, the fine is per violation per day.
And that's per unit.
I would make the argument that it's per unit. Yeah, so each unit is a violation, so it's $100 each day.
Can the ordinance have some language in there where if you have outstanding violations, you can't get a permit to do things, or?
No.
No, unfortunately, I think the best we can do is lien on the property.
Yeah.
Okay.
But, you know, the violations rack up quickly and people react to that.
Okay.
The fines, people react.
Anything else, Chairman?
That's it.
Commission comments? Bob?
No comment. Welcome, Molly. I'm glad you're here. Take some of the abuse we take.
Thank you. Happy to be here.
And we're looking for you for a silver bullet against HRG.
I guess 8:30, Chief.
Molly, any comments?
No, I'm just happy to be here. Looking forward. Sorry I'm not there in person. I've got 2 sick kids at home, so.
No, I get it. Totally understand. Down there, Ken? Yep. Eric, good. Yeah.
Happy holidays, everyone.
Yep, I'm good too.
Happy holidays to everybody. Sorry I'm so
Sorry to
quiet.
do that to you guys and gals, but, 2002, and this is really more for you, Jeremy, the priority housing development, the 10% of developable land as a minimum and not to exceed 20%. That requires us, really staff, to do a significant amount of work as to what plots of land would fall under that description. And I think it's something that we need to get started in parallel with everything else that we have going on.
Can I jump in, Mr. Chair?
Yes, please.
My comment, by the way, congratulations to all the new board members. Very cool. Glad to work with you. Things are gonna come hot and hefty, to your point right there we talked today. I've already asked Tyke to put together a quote on getting together some of this information. We have a lot of things in 8002 that take effect the beginning of July. So there's a couple of things we're gonna have to look at. That's one of them. So I've already asked them to start putting together a quote, and then I'll come back to you guys and, you know, see where we go next.
Well, what are you specifically talking about? What needs to be
This is
determined?
the new,
No, I know the bill. What line item there was that you?
oh, you're welcome to take, it's all highlighted. I couldn't
Yeah.
quote you the line number, but
There's a couple of big ones too. There's parking zones we gotta look at. That's a big thing. There's also the regulations for summary review of commercial properties being converted to residential. Those all take effect right away on July 1st. So I think those will be our priorities. I'm not sure about when that one takes place. I didn't see that.
I thought it was July of
It could be. But anyway, these are things that you know, this is a mandate on the town. And all the towns right now are scrambling to find, you know, planners and stuff to help us do this work. So I turned to them right away because we're already working together. They do it. Westcog is looking into ways to do it, but I think we're going to do our own thing because July 1st is going to come quick. So,
Eric, I just want to add, and again, congratulations to all the new members. In line with what Dan was saying about 8002, there's a lot to be done before July 1st. Westcog did put together a presentation kind of summarizing it. I don't know if that's. Okay. The other thing is they're gonna be helping towns in their district with some support. I think they're looking to get some consultants pre-qualified to help do this kind of work. And of course, with things like traffic mitigation zones, my office will help to the extent we can as well. So, you know, I'd see it as kind of all hands on deck until July 1st, because it sounds like there's a lot that needs to get in place to avoid getting, you know, slammed after that. So.
Anything else? Nope. I have nothing. So I'll make a motion to adjourn the meeting.
Second.
Second.
All right.
your vote.
All in favor?
Aye.
Opposed? Want to keep it going?
Thanks, everyone.